All right, so let's talk about the next question that comes up, which is how much does a nursing home case cost? A lot. You gotta have an expert, and experts are expensive. The law firm pays for the expert and gets reimbursed out of your settlement. You should expect 2 experts at a minimum in your case. The first is the causation expert. That's a nurse or somebody with experience in the nursing home industry who can tell us what safety rules applied, how they got broken, and how breaking those rules caused the harm sustained by the resident. And then you also need to need a treating doctor as an expert who can tell the nature and extent of the harm suffered by the resident as a result of the neglect. These experts alone can cost more than $10,000, and it's just critical to get professional help to find the right causation expert because they are the most crucial witness in the case. You're going to have other costs that can run into hundreds or thousands of dollars, and these are the biggest one. Number one, getting copies of medical bills and records. Number two, mediator costs. You're probably going to have 2 mediations. That's a process required by court rules where both sides hire a lawyer who isn't involved in the case, who's got a lot of experience in these type cases to help them get it settled. And then the third major cost you can have is court reporter fees for depositions. They type up a transcript and send it out to all the lawyers. So that brings us to the next question. How long can a nursing home case take? The best way to answer that is to just give you an overview of the process of an entire case. Now know this, a case can settle at any point during this process if it's the right thing to do. So let's talk about these phases of your nursing home case. Phase 1 is investigating the nursing home's conduct. That can take 3 to 4 months. What we're going to do is first have you get copies of the facility's records. The reason why we get you to do that is if a lawyer requests the records, alarm bells go off, wagons begin to circle. You probably won't get all the facility records, but hopefully enough to give us a head start. The next thing we might have you do is contact the state authority overseeing these facilities. It's called the long-term ombudsman. And what the ombudsman can do is investigate the facility to see if any wrongdoing contributed to or caused the harm to the resident. Now, what you need to know about them is their powers are extremely limited. All they can do is assess slight fines and request operational changes. They cannot order a settlement to compensate the resident. And then what we're also going to do as a law firm during that time is begin to find the right expert. We've got to find an expert who's both knowledgeable in the information they're going to testify about and one who communicates well, who could testify well in front of a jury if your case goes to trial. We're also going to get copies of all medical bills and records related to the treatment required by the resident as a result of the harm. That takes us to the next phase, which is the pre-lawsuit phase. That can take another 3 to 4 months. What we do during this period is we file what's called a notice of intent to sue. It notifies all responsible parties and facilities we intend to file a lawsuit. It's required by South Carolina law. It lays out some basic facts surrounding the injury and the harm, but the centerpiece of it is our expert's affidavit. An affidavit is a sworn statement in proper legal form laying out how the facility caused or contributed to the injury or death. That gets served as required by law on all those parties who have a right to respond. Then everyone can start subpoenaing evidence to get copies of various documents like medical records and bills. At some point during this process, we've got to have what's called a pre-suit mediation. That's where, again, we hire a lawyer who is experienced in these cases but isn't involved in yours, a neutral party, to help us get the case settled. Most of the time, it's too early to try to have meaningful settlement talks, but sometimes this process can get those talks jump-started, which can lead to an earlier settlement down the road. Most of the time, as I said, these mediations don't work, and when they don't work, we move on to the next phase of the case, which is actually filing the lawsuit. That takes another 60 to 90 days. We file the lawsuit, which basically restates what's in the notice of intent to sue, plus some other legal details, and of course it includes our expert's affidavit. That's served as required by law on all responsible parties. They get to legally respond with a document called an answer. After that, we move to the longest phase of the case. It's called the discovery phase.